right. Hello, everyone, and thank you so much for joining us for today's webinar. My name is Dustin Saldarriaga, and I'm a senior associate at Scott Legal PC. Today, we're going to be spending some time talking about the EB2 National Interest Waiver, or NIW for short. This is a green card category, and it is underutilized, and one that we've seen becoming more and more popular, though, because it does allow entrepreneurs to petition for themselves. The NIW can be particularly helpful. I'm sorry about that. I just realized my video was off. The NIW can be particularly helpful for those who are currently on an E2 visa and are looking to move from that visa, which is a non-immigrant visa, to a green card option. We're very fortunate to have my colleague Jiyae Hwang here to speak with us. Jiyae is a senior associate at the firm and has extensive experience guiding clients through the EB2 NIW application process. A few things before we get started. Our firm is a full-service immigration firm, and though we do focus on business immigration, we handle the full range of U.S. immigration cases, whether that is family-based immigration, humanitarian, or of course business. So regardless of what questions you have about U.S. immigration, we do hope that you'll come to us for any assistance you might need. This webinar is part of a series. We do at least a couple of webinars a month. Usually we'll do 4 to 6 a month. And they do span the full spectrum of topics on U.S. immigration. So we hope that you'll sign up for our future webinars, and that we'll see you again on those in the future. After this presentation, we will be sending out an email with a link where you can sign up for those webinars, as well as a copy of the PowerPoint that you see on your screen. We'll also include a comprehensive guide to the NIW, which really does compile the best information that we have about the EB2 NIW. In that email, we'll also share a link to our YouTube channel. We do post both full-length webinars as well as shorter videos on, again, a variety of immigration topics on our YouTube channel. So we hope you'll check that out. This webinar is being recorded and will be posted to our YouTube channel. If you have a question during the presentation, go ahead and send that in through either the question and answer box or the chat function of Zoom. I will be monitoring those, and I'll share those questions with Jiyae so that she can respond to them by the end of the presentation. And again, this webinar is being recorded and will be posted to YouTube. So without further ado, I'll go ahead and pass it off to Jiyae.
All right, thanks so much, Dustin, and thank you everybody for joining us today. I'm happy to share my insights about the National Interest Waiver. So let's start with the basics. What are the National Interest Waiver requirements? Now, as Dustin mentioned previously, NIW is short for a National Interest Waiver, and it is a subset of the EB2 employment-based immigrant petition. Now, immigrant petition means this is an application for a green card. So you would get U.S. permanent resident status out of it if and when your application is approved. And a green card, as you may know, gives someone the ability to live permanently in the United States and work for any employer or not at all. So having a green card gives a lot of opportunities and privileges, and having a green card also opens the pathway to U.S. citizenship in the future if that is among your goals. Now, the EB2 NIW is a popular choice among individuals who wants to apply for a green card on their own, and this is called self-petitioning. And this means you can apply for the green card as an individual, whereas normally, in typical circumstances, you will need a U.S. company to sponsor you for a green card for a U.S. job opportunity. And very frequently, if you do that, there are restrictions on the kinds of ownership percentage you can have on the U.S. company that is sponsoring you, and also the U.S. company needs to go through what is called a labor certification process, which is that the company actually needs to test the U.S. labor market to prove that there is no qualified, willing, and available U.S. worker to take that spot before they can sponsor somebody for a green card. So this can be a very lengthy and complicated process, but the EB2 NIW provides an exemption for that. And another popular category among people who have exceptional or extraordinary ability is the EB1A. extraordinary ability, immigrant petition category. That is another category that allows self-petitioning without the need for a U.S. job offer, without the need for a U.S.-based sponsor. However, the EB2 NIW, as opposed to the EB1A, can be a more viable option for a more wider variety of professionals in various stages of their careers who can show that their work will make significant contributions to the industry or society. So this can be a very attractive option for a lot of people. Now, let's look a little bit at the eligibility criteria. So what are the eligibility criteria to qualify for a green card under the EB2 NIW pathway? So the first thing to note is the threshold requirement to qualify under the EB2 category itself. And this is a common requirement for, the more typical case where you are applying with a U.S. company sponsoring you, and also a threshold that you must meet if you opt for applying for an NIW as an individual applicant. Now, you can meet the EB2 threshold in 2 ways. So the first way is through showing that you have an advanced degree or its equivalent. And what does that mean? Let's unpack it a little bit. So an advanced degree means a master's degree or higher. So for example, if you have an MBA, that counts as a master's level degree. If you have a JD, for example, that also counts as a higher level advanced degree because you need a bachelor's to gain admission to that kind of degree. An MD can also qualify as an advanced degree because you typically need a bachelor's degree to gain admission to an MD program. A PhD, obviously, if you have a PhD, then it'll definitely count as an advanced degree. One thing to note is that if your advanced degree is from a foreign institution that is not within the United States, from a Canadian university or, South Korean university, for example, you will need to get a U.S. equivalency report. So an educational equivalency report is a report issued by a evaluation agency that confirms that the level of education that you got from that foreign degree is equivalent to the same level of degree in the United States. So you will need to also obtain that if you have a foreign degree. Now, if you don't have a master's degree, is there another way you can qualify as an advanced degree professional? Yes. So let's say you have a bachelor's degree in your field. And let's say after you obtained the bachelor's degree in your field, you accumulated more than 5 years of progressive work experience in your field. Now, what does progressive work experience mean? It means that your job duties and your responsibilities did not stay static over time, but your duties and your responsibilities changed and increased in complexity as time went on. So this can be shown in a variety of ways. This can be shown by changing titles from, associate attorney to senior attorney, for example. This can be shown by increasing wages. If you, receiving a base salary, but then your wages increase over time, you can say that. More importantly, though, this can be proven by a letter from your employer talking about how your duties change in complexity over time, and you took on more complex and more senior duties as time went on. So if you can prove that you have 5 years of progressive work experience after you received your bachelor's degree, you can also be counted as an advanced degree professional and can meet the EB2 category that way. Now, what if you don't have a bachelor's? What if you don't have a master's? What if you don't have 5 years of work experience? Then another pathway you can think about is, do you meet the criteria for exceptional ability? Now, exceptional ability in the sciences, arts, or business, it is a very different kind of what do you call it, ability threshold compared to what is called an extraordinary ability, which is the standard that we use for EB1A petitions. Exceptional ability is a little bit of a lower standard, right? So what you need to prove is that you are a professional who is working at a level that is significantly above what is ordinarily expected, ordinarily encountered in your field. And there are very specific types of evidence you need to be able to show exceptional ability. And it is kind of a term of art in a way. So you do have to meet at least 3 out of the 7 criteria that we list here below. And those criteria include, for example, 10 years of full-time experience in your field. And how do you prove that? You will prove that through letters from your previous employers talking in detail about what you have done and how you have worked and what were your working conditions. You can also show that you have a degree, diploma, or any type of certification related to the area that you're practicing, and it does not need to be a bachelor's degree. You can also prove that you command a higher salary compared to other ordinary professionals who are active in your field. More importantly, one category that I want to point your attention to is significant recognition for your achievements in your industry, by peers, by government entities, by professional or business organization. And I think that is a very important criteria to fulfill, because that is the narrative that you will develop on why what you are doing is different from the vast majority of other professionals in the industry, right? So why does this prove that, you are operating at a level that is significantly above what is ordinarily encountered? And this can be proven in a variety of ways. Like, for example, if you are an engineer, did you help develop a product or technology that was patented? If are a product developer, did you commercialize a product that was, mentioned widely in the media and, shortlisted in industry conferences and things like that? So there are a variety of evidences you can collect to really show that you are someone who has done things that commanded a lot of attention in your industry. And that is an important thing to consider when you are preparing your argument for exceptional ability. Now, let's say that you are able to meet the EB2 threshold through either showing that you're an advanced degree professional or you're a professional of exceptional ability. Now, the next step of the eligibility analysis is, do you qualify for a national interest waiver? And this part is very important, and I would say the key, the core part of preparing for an NIW case, because if you don't qualify for the NIW, what the government expects you to do is for your employer, the U.S. sponsor, to go through what is called the ordinary, labor certification process, basically testing the U.S. labor market, seeing if there is anyone else in the U.S. available, willing, and qualified to take the position. But if you can meet the three-prong matter of NSR criteria for the NIW, you're allowed to basically bypass that process. And so the NIW is basically more of like a fast track to a green card, because then, because for these reasons, the government will think, okay, the ordinary benefits of a labor certification is outweighed by, these significant, contributions that this person can make to the industry. So let's exempt this requirement so that we can have this person come to the United States faster. So what are the three-pronged matter of NSR criteria? So the first criteria is that the applicant must prove that their proposed endeavor in the United States have both substantial merit and national importance. Now, what does this mean, right? So substantial merit can be proven in a range of fields, including the arts, the sciences, business, even culture. And usually any sort of endeavor that, proposes a benefit to society in some way, right? That is likely to meet the criteria for substantial merit. Like, you are providing excellent goods or services to, a particular area that can meet substantial merit, bringing some sort of benefit, right, to the economy or society. Now, the challenge, though, is to meet the national importance criteria, right? So how do you prove that your work has national importance? So to say it in simple terms, what the government is looking for is an endeavor that has national or global implications in a particular field. That means what you're doing is something original that is not available otherwise, that other professionals are doing, but you're doing something that is better. You're doing something that contributes to advancing the field in some way, right? So, for example, if you're working in the semiconductor industry and let's say you are helping R&D, research and development, in increasing the density of a particular chip, right? So if a particular chip, the industry standard is like, you have a certain type of, a certain level of data that is in a particular area. What if your new technology, like, let's say you think of a way to vertically stack these, chips or whatever, and then now you have, even more data storage potential in the same area, which can really revolutionize the industry, right? So those kinds of kind of endeavors that tend to push the envelope of the industry as a whole, those types of endeavors I have seen is favorable in meeting the national importance requirement. And some of the examples that the government gives in the matter of dinosaur case law is medical advances or improved manufacturing processes, right? And you can see that if you have advancements in those areas, the trickle-down effects of, positive impacts to society, whether it be economic development, whether it be societal advancement, whether it be, public health, increasing welfare of a particular marginalized population, or increasing economic development in an economically depressed area, for example, like those kinds of broad-based impact to a important area of, for the nation, those types of endeavors would likely meet the criteria for national importance. Now, the second criteria then is the applicant himself or herself must be well positioned to advance the proposed endeavor. And what does that mean? So in this prong, the government will look at the person's record of previous work. So for example, your education, relevant education in that area that you're proposing to work in. So if you're proposing to, develop, new cybersecurity programs, do you have relevant education to help you do that? Like, do you have a computer science degree? Do you have a engineering degree? What about your professional experience? How can we know that you will be able to actually carry forward this endeavor and realize those broad impacts to the industry? Have you had success in similar endeavors before? Have you accumulated many years of specialized professional experience that gives you the unique know-how and the technical knowledge that is, expected to really help bring this project forward? So although the project itself is important, if the government thinks that you are not qualified to bring forward the project, then the application would not be successful. So really, you want to develop a portfolio of previous projects that show that you have done similar things in the past and that those similar projects have also been very impactful to the industry. So those kinds of cases would be most favorable for NIW approval. Now, then let's move on to the third prong. The third and final prong is, on balance, is it beneficial to the United States to waive the labor certification requirement for this particular individual? And this argument can be approached in a variety of ways. So, for example, you can lean on the first prong, talk about the broad-based benefits of your proposed work to the United States, such that, the benefits that you bring with your particular endeavor is broad enough to outweigh the ordinary benefits of the labor certification process that secures, one job for one U.S. worker. Another popular argument that entrepreneurs can make is the economic benefit argument, right? So if you are running a business and you have actually generated U.S. jobs, a number of U.S. jobs in the past. And if your continued work in the United States will either, maintain these jobs or even create more jobs, high number of jobs in the United States, then obviously the countervailing benefits of, securing, the labor certification process is greatly outweighed by the positive job creation prospects that your business endeavor will bring. So that is another popular way entrepreneurs can use the third prong to their advantage. It is very important that an applicant needs to meet all three prongs to be approved for a national interest waiver. So even if you're an entrepreneur and you say that you're creating jobs, so that will be favorable for the third prong. If you failed prong one, if you failed prong two, unfortunately, the NIW is not going to be successful. So it is important to remember that an applicant needs to meet all three prongs in order to qualify for the NIW. All right, so the next topic that we'll cover is how the National Interest Waiver Green Card pathway can be used for entrepreneurs and is a favorable category for entrepreneurs. So the previous case law that came before the matter of dinosaur case law really changed the way that the government looks at what is called national importance, right? So the previous case law really focused on what is the geographic scope of the endeavor, right? In the previous case law, they really looked at whether the impact of your work can be felt in basically every state of every geographic corner of the United States when they were looking at whether an endeavor has national importance. However, with the new case law matter of Dinosaur, the government explicitly moved away from this geographic focus, right? So now under the new case law, even endeavors that are focused on one geographic area can have national importance. For example, let's think about an entrepreneur bringing a large-scale development project in a particular area, which is known to be an economically depressed area. So let's say it's a specific county in a state that is flagged as one with high unemployment rates, depressed real estate prices, etc. And let's say the entrepreneur worked with the local governments and also got letters of intent with those government officials, really talking about why it is important to bring this development projects to this particular region. Now, that kind of project can be well said to have national importance, even though that project will really only, focus on revitalizing one particular region of the country. So the new case law and the new standard definitely makes entrepreneurs have more options when they're thinking about what kinds of projects they would bring to meet the national importance requirement. The second major change that happened is that the matter of Dinosaur case law explicitly mentioned that many entrepreneurs are considered self-employed, and therefore they're often not eligible for a green card under the traditional labor certification requirements, which is a limitation that they, explicitly recognize, such that they have started thinking that NIW could be a viable option for entrepreneurs to gain a green card because traditionally the other options may not practically really make sense for them. So for the third prong, right, for the purposes of the third prong, entrepreneurs can certainly now use the fact that it would be impractical or even impossible for them to obtain a green card through the traditional labor certification process to show that on balance, it is beneficial to waive the requirement for this particular endeavor, because otherwise they would not have the opportunity to gain a green card in the United States, even though their work is important to the United States and they are well positioned to advance the endeavor. So you do need to meet all three prongs, but provided that you meet prong 2 and prong 1, prong 3, entrepreneurs could have a leg up on that regard. The final note to make here is that matter of Dinosaur specifically notes, and I think I've mentioned this, alluded to this a little bit before, but entrepreneurial work can indeed lead to an NIW. And the case law explicitly states that the planned venture does not need to actually be successful, as a result, as long as you can show that it is plausible. It is a plausible plan, it is a well-researched plan, and it is likely that, you're well positioned to advance the endeavor, then you can be approved for the NIW, even if the venture ultimately fails. All right, let's then shift gears a little bit and talk a little bit about some strategic considerations on, that is important when you're considering applying for an NIW, because an NIW is a green card application. And there are some things that you want to consider before you apply for an immigrant petition. So let's talk a little bit about the timing. So getting a green card is a long-term project. It is not quick. It can take many years until you have the green card in hand. And it is also helpful to note that it is kind of a two-step process, right? So there is the underlying petition, which is also called the I-140. It is the immigrant petition for alien worker. And you would file that to prove that you are eligible for a green card under the NIW category. Now, once you are approved for that, there is the next step, which is the green card application itself. And if you're already in the United States on a different non-immigrant status, you can use what is called the adjustment of status process, where you would file what is called an I-485 application to, basically adjust your status to a permanent resident. So that's one option. If you are abroad, if you're living in a different country, you can also use the immigrant visa process through your home country consulate, for which you would, get an immigrant visa stamp in your passport, and you would come to the United States and land as a green card holder when you make that entry. So it is the two-step process. So now let's talk a little bit about how much time you can expect for these processes. So let's start with the I-140, which is the underlying petition that you need to submit to prove basically that you deserve a green card under this category. And so a very positive change that came down in the past several years is that premium processing is now available for NIW application in the I-140 stage. So the underlying immigrant petition now can be premium processed. So the timing is 45 days, 45 calendar days. After filing, if you use premium processing and pay the extra fee, you will receive either a decision, a request for evidence, or a notice of intent to deny within 45 calendar days. And let's say if it's a decision, then that's the end of the matter. Let's say if you receive an RFE, or request for evidence, you would get a certain period of time where you are allowed to prepare your response. And once you prepare the response and send it over, the government will also process the response within 45 days and then will render you a response. Usually it's the final decision. So either 45 days or 90 days, depending on whether you get an RFE or not. And you can also take into account the response time if you do get an RFE, so you get the picture of how much time it will take under premium processing. If you don't pay for premium processing and use regular processing, it usually means that your I-140 itself will be processed in about 1 year after you file it. So that is another significant difference in processing times that you want to be aware of. Now, after you receive the approval on the I-140, and if you move on to either the I-485 or the immigrant visa process for getting the green card, that it also in itself can take an additional year to process, because green card processing takes some time. And another thing I will get into in the later slides is that there's also this thing called priority dates. Now, what does it mean, priority dates? It means every year there is a set quota of immigrant visas, basically green cards, that can be issued. And if there are more qualified applicants than there are visas available, it creates kind of a backlog, which means there can be a little bit of a waiting time until you reach the front of the line. Before you can apply for the actual green card. So there could be an additional waiting period before you can, file your I-485, before you can file your immigrant visa petition. So that is another delay factor, potential delay factor that you may want to think about. Now let's talk a little bit about the question of underlying visa status. So let's say you are on a non-immigrant visa that does not allow for dual intent, and a very easy example is the TN visa. It is a visa category that is quite strictly scrutinized for immigrant intent. After you file the NIW petition, the I-140 even, right? You could get more scrutiny at the border when you're applying for a renewal of your TN visa or you're applying for a new TN visa, because the officer may think that you having filed the I-140 is somehow an expression of immigrant intent. And in order to qualify for those non-immigrant visas, you need to show that you do not have immigrant intent. You only seek to enter the country to work temporarily and to leave. And so for certain types of visa categories, a better strategy may be to go ahead and renew that visa first before you file the I-140. And after you have successfully renewed the non-immigrant visa, and let's say more than 90 days has passed, and then you file an I-140, that can be a better strategy depending on your circumstances. So definitely speak to your attorney to figure out the best timing strategy for that. Now let's talk a little bit about the application process. What you would do is submit the form I-140, as I mentioned before, with the proof that you meet the EB2 NIW qualifications. And let's say that you are approved for that, and let's say that the priority dates are current, which means there are immigrant visas available for your category, and it also depends on your country of birth as well. So let's say the priority dates are current for your category, then you are able to file the next step application, which is either the I-485 adjustment of status application or file for an immigrant visa if you're not in the United States at that time. Now, concurrent filing right now, the EB2 category is backlogged worldwide, so there is not an option to concurrently file the I-45 with your I-140. But I mean that could change, right? So if you look at the visa bulletin and if it says current for that particular category, that means you are able to concurrently file your I-140 with the I-45, and that actually has been true, I would say, like up until like mid 2022 even, but starting from November 2022. The NIW EB2 category has consistently been backlogged. So clients who filed the I-140 after November 2022 needed to only file a standalone I-140, and then after that has been approved, they were able to, wait till their priority date's been concurrent and then file their I-45 or file for an immigrant visa. So priority dates are a very important consideration that you want to think about. Definitely speak to your attorney if you would like to, understand more of what that means for your particular situation. Yeah, so is the category current? That is what I've been talking about regarding the priority dates. It is a very important question. If the category is current, you can, move on to what is called the second step of the green card application by either filing the I-45 or immigrant visa application. If not, then you do need to wait a little bit. Pros and cons of adjusting status in the United States versus consular processing. So the most significant advantage of filing an I-45 to adjust status in the United States is that you're able to continue living in the United States up until your green card application is adjudicated. So even if you run out of your current status, if you file your I-45 before your current status expires, then even if you don't have any other underlying basis, you can continue living in the United States up until the adjudication of your green card. And with the filing of an I-45, there is also associated benefits with that. For example, every applicant for an I-45 can apply for an EAD, what is called, an employment authorization card. You can file the I-765 concurrently with your I-485. And what that does, it basically gives you an open work permit, right? So once you have the EAD, you can work for any employer you want. It gives you a lot of freedom. So that is one benefit that comes from adjusting status in the United States. Now, if you're in the United States and you file the I-45, there is a period where you can't travel outside the United States without abandoning your application. So that can be, a disadvantage of filing the I-45, and is also an advantage of going for consular processing, which is the other option. So if you file the I-45, you should likely also file for an advance parole, which is a document that allows you to, travel in and out of the United States temporarily while your I-45 is pending. But the advance parole can take a while to be approved, right? So before you have the advance parole and after you file the I-45, there could be a period of time where you're just simply not able to leave the United States without abandoning your application. So if it is very important to you to be able to travel in and out and not have any interruptions in that, then consular processing could be a better option because you basically route your application through your home country consulate instead of, staying in the United States and waiting there. So the advantage of consular processing is that you preserve the ability to travel in and out. But note that once you have filed the, I-140 and expressed some sort of immigrant intent, there could be, more possibilities that you could be questioned about your intent on non-immigrant visas. So that's another thing you want to think about and talk to your attorney about if that's what you're considering. But let's say that you are processing, through consular processing, right? If you don't have any other underlying basis, non-immigrant visa basis to be in the United States, it could be that, then you may not be able to continue living and working in the United States without any other independent basis, right? So you could be waiting outside of the United States for a while. So it really is a choice of what is your preference. Would you prefer to live and work in the United States while you wait for a green card to be adjudicated, or would you prefer to, process the whole thing from outside the United States? So it could really depend on your individual circumstances. All right, so then let's shift gears a little bit and let's talk a little bit about, some policy updates that came down in 2022 that, made it, favorable for certain types of STEM applicants, science, mathematics, engineering, technology professionals, and entrepreneurs uh, who, are considering applying for the NIW. So the gist of the STEM specific guideline updates, right? So one thing that you really want to think about if you're a STEM professional is your endeavor related to advancing any of the critical and emerging technologies that the government finds important? And now the government also had a series of announcements, policy, reports that talks about what these areas are. So there is a list of what is called the CNET technology list. And if your endeavor is, one that, is doing some R&D research related work in those areas and in academic or industry settings, right? So even if you are, someone who works at, just a semiconductor company, doing R&D on an industrial application of certain types of technologies, you don't need to be, a researcher affiliated with a university or anything, right? You can be, practically doing industry research, but that will still be relevant in the question of whether you would be considered someone who is doing work of national importance. And if you have, an advanced degree in STEM, that can be, very helpful to proving that you are well positioned to advance that kind of endeavor. So I will read a little bit of examples of what the government considers is a CNET, right? So these include things like advanced computing, advanced weapons technology, advanced engineering materials, advanced manufacturing, advanced sensing, advanced aero engine technologies, agricultural technologies, artificial intelligence, AI, obviously, autonomous systems, machine learning, biotech, communications and networking technologies such as 5G networks, data science, storage, data processing technologies, distributed ledger technologies, energy-related technologies, medical and public health-related technologies, quantum science, semiconductors, space technologies are some of the examples that the government has explicitly noted that are areas of national interest. And if you have a PhD in that relevant STEM area, that can be an especially positive factor for you being found well positioned to advance this endeavor. Now, let's then talk a little bit about what are the entrepreneur-specific guidelines that were updated in 2022. The gist of what you need to know is that now entrepreneurs can prove that they are either, well positioned for an endeavor or that their endeavor has national merit, national importance, substantial merit, for example, with non-traditional forms of evidence. So if you look at, the typical, profile of an NIW applicant, you tend to think of researchers with PhDs who have tons of publications, tons of citations, have authored patents and things like that. Entrepreneurs don't tend to fit that profile that neatly. So what the government did is gave some examples of what other forms of evidence that can be relevant in proving that your work will have this sort of broad impact without, resorting to the traditional metrics like a Google Scholar, Google Scholar citations and things like that, right? So what are some of these examples? So let's say, for proving substantial merit and national importance, media articles, significant media attention on the particular project that the entrepreneur is bringing, or, significant media attention on the entrepreneur's work in the past that can also be used to support the fact that their future work will have similar impact. Awards or grants from government entities for the prospective proposed endeavor. That can be a very powerful form of evidence. Letters from third-party investors, such as, venture capital firms. And I think it is better if the venture capital firm is an established venture capital firm. If you, for example, if you have a startup idea and you have gained admission to an accelerator or incubator, and if that accelerator or incubator is a well-known and respected incubator in the industry with, high-ranked, credentials, that can be a very powerful form of evidence showing that your work will have a national level impact, because if it disrupts the industry, it will disrupt, the nation. Letters from government agencies can be very helpful in proving national impact. For example, if you are an entrepreneur who is proposing to bring a project to an economically underdeveloped area, and if you can get a letter of confirmation from the person who is in charge of that economic development in that particular area, who is a government official, that can really help bolster your claim that your work will have that national level importance by revitalizing that particular region. Evidence of revenue generation, growth, and job creation. If you have a very steep growth, pattern for your, enterprise that you've been working on in the past, if you can show that through tax returns, show that to W-2s, showing that you have experienced that explosive growth, you can use that to, to prove that your enterprise will grow even further in the future and, produce exponential impact. That can support a claim of substantial positive national impact, substantial positive economic impact to support national importance. What about well-positioned? So there are some examples, again, that entrepreneurs can rely on to prove that they are well-positioned to advance the endeavor. That can include ownership and critical role in the US-based entity that is proposing to do something of national importance. Degree certifications, that show that you have the entrepreneurial skill set or the technical, knowledge to bring the project to fruition. Letters from experts that you have worked with in the past, describing your record of success in previous related endeavors, that can be helpful in showing that you're well positioned to also bring this project to success. Evidence of interest in, someone wants to invest in your company, that can be, that can prove that you are someone who is able to secure that kind of investment. So that can be helpful. As I said, incubator and accelerator participation can also show that you're well positioned because you're the one who, secured that invitation to the accelerator. Receipt of government grants for either this project or past projects in the past, that can be a powerful record to showcase. Intellectual property. So if you have already, maybe developed new technology that you want to commercialize, and if that technology has already been patented, right, you can include a copy of the patent, and that can also be independent evidence that you are bringing something original to the industry, because an invention is by definition original. It is unique, and that is why it has been patented. That can serve as, a third-party validation of, the innovation that you're bringing to the table. Media attention, revenue growth, as I mentioned before, those can also support that you are well positioned to, bring your project to fruition, because you have, gained that validation from the industry of, the significant impact of your work. So all of these types of evidences really help show that your work in the United States will go beyond just helping your immediate customers, right? There's something about your work that the industry is paying attention to. And that is, I would say, the key of an NIW. You really want to show that your work will make a big splash in the industry, as opposed to just providing good services that will, help your clients. You want to really prove more than that. All right, so then let's talk a little bit about the nitty-gritty details of what you need to do to prepare a successful NIW submission. The document requirements are quite extensive. So the first thing you want to consider is, do you have proof that you meet one of the threshold requirements, either by proving that you are an advanced degree professional, or by proving that you are someone of exceptional ability. And as I mentioned in the previous slides, if you want to prove that you are an advanced degree professional, you would obtain the copy of your degree, of that relevant advanced degree. You would get the U.S. equivalency, U.S. educational equivalency report from an accredited institution that shows that your foreign degree is equivalent to a U.S. degree of the same level. If you are meeting this threshold by showing a bachelor's degree in your field with 5 years of progressive work experience, you do need to have those employer experience confirmation letters proving that not only that you work for 5 years, but also describing how your duties change in complexity and seniority over time. So you do need to have a proof for that piece as well. If you're meeting this threshold through exceptional ability, you need to show at least 3 out of the 7 evidentiary criteria that I mentioned, which includes things like, 10 years of full-time experience, relevant degree, diploma, membership in professional associations, and also recognition, evidence of recognition for original contributions to your field. Generally, the evidence that is collected, 3 out of the 7, must also, holistically show that you are someone who is operating at a level that is superior than what is ordinarily encountered in the field. So if all of the evidence that you collected tend to show that, then it is likely you will meet the exceptional ability threshold. So now, once you are able to present the evidence that meets the criteria for the EB2 as a whole, the next challenge is to show that you meet the 3-pronged matter of Dennis criteria. And as I mentioned before, you need to show that you meet all 3 criteria in order to qualify for the NIW. So, for example, to prove that your proposed endeavor has substantial merit and national importance, some of the evidence that you can collect are, copies of news articles, academic papers, market research, to really give the background information of what you're doing about your field, and because it's relevant to showing that what is the limitation that the industry is currently facing, and why is it important to America to have you come in and suggest improvements to what is already there. Like, what is the field that you're working with? Why is it important to America? Executive orders and legislation and government investment in a particular area can be evidence that this particular area is important to the US's national security interest or policy interest. One important thing is to note that even though it is helpful to have these general articles talking about, the industry, you do need to supplement that with evidence of why your specific endeavor has a significant impact to those national priorities, right? So if you can say, oh, okay, I'm just going to work in clean energy, that may not, cut it, even if you have, a volume of evidence showing that clean energy is important to the U.S. economy. If you can't show the specific link between your particular work and, how it is going to significantly impact that national priority, that could be also a tough case. So you do need to make sure to have very specific expert letters that describe the impact of your work and why does it stand to significantly advance those areas of national priorities. So I talked a little bit about the expert letters. Another function of the expert letters is to show that you're well positioned to advance the endeavor. So how does that work? The expert letters will talk about your previous projects, related projects that you've done in the past that had a similarly large scale impact, and they will likely, develop the narrative of what you do that is different from the others, right? So that can also help with the 3rd prong if you have, irreplaceable skills and, just unique know-how that cannot be replicated by just another U.S. worker with minimum credentials. That can also help your case. And the expert letters can do a very good job of bringing that out so that it is visible to the officer. So expert letters do a lot of the persuasion in an NIW case. And that is why it is very important to, work with a competent lawyer who can really guide you through the right content and the right presentation in those expert letters. Now, also relevant could be the applicant's resumes, degrees, proof of professional accomplishments, and those third-party, proofs can take the form of awards, patents published, publications, conference presentations that you've made. All of those things tend to illustrate, by way of corroborating evidence that you are someone who offers something original to the industry. So they're really looking for a past history of success in a relevant field. They want to see that you're an outstanding figure. Although not to the level of a, extraordinary ability EB1A petition, you do need to show somehow that you do have that public attention, a degree of public attention over your work, because you want to show that your work has a broader impact than just benefiting your immediate clients or your immediate employer. In the case of entrepreneurs, one type of evidence that you can consider adding are, high value, high profile contracts with industry leaders, letters of intent from, venture capital, partners or, other business partners who are invested in your idea that can also support that your idea has merit and potential. if you, obtain startup capital from any source, that can also be helpful to show the plausibility of your business plans, and also to show that your plans are likely to become a reality, that you're committed and serious about your project.
And Jiyae, one question came in that's related to this. How many
Sure.
expert letters do you usually recommend as a good number?
That's a good question. So I would say, as a minimum, I would recommend doing it maybe like 4 as a minimum. And we've also had cases that include as many as 6. It really depends on what we're trying to prove, right? So it also depends on the function of the letters. Like, so what are the gaps in your, resume? What are the gaps in your case, and what do we need the expert letters to bolster, right? So, the strategy will really depend on the individual case. But yeah, for a stronger case, I would say, yeah, like 4 letters, even 3 letters, that could work. If you otherwise have, a robust volume of evidence that supports the broad impact of your work. But in some cases, you may want to go with 6, maybe even more, if there are many specific points that you want to hit that is not adequately covered by the other forms of evidence.
Perfect. Thank you.
All right, so then let's talk a little bit about a little case study of an approved NIW case that was published in one of the AAO opinions. That gives you a little bit of a general idea on what kind of case that could be successful, and how to prove it, each prong, how to support each prong in an NIW case. So in this particular case, the applicant was an entrepreneur who proposed to form a small consulting firm to work on projects focused on improving services that are given to U.S. veterans. So basically, people who have served in the military in the past and came back, maybe have, having some wounds and, trauma, and how to really help these veterans regain, their place in the productive economy. So this person proposed to coordinate, specific organizations in philanthropy and government in the United States. And really, this person proposed to facilitate the, creation of projects, programming to really facilitate this reintegration of returning veterans to productive society. Now, so what this person did to support the substantial merit and national importance of this work is they prepared expert letters from those who had senior positions in U.S. organizations that were covering the industry, right? So government officials, nonprofit, organizations, people who held senior positions in there. The applicant gathered expert letters from those people to support the claim that he had a project that filled a need in this particular industry, that filled a need in existing program offerings. If there was a lack of programs that are facilitating reintegration, why do we need this program, and why does this person's project have the potential to significantly improve the status quo in this particular area. So news and media articles and research reports about the plight of returning veterans really helped contextualize this area, and helped to prove that this is an area indeed that the government thinks is important to advance. Now, what about well-positioned? So the applicant provided letters from similarly senior officials in the UK, where this person was active in the past, really describing the previous related projects that this person helped facilitate. And really, these letters did a good job of bringing out the narrative on what was the end result, what was the impact of those projects. So for example, one of the projects that this person organized ended up gathering millions of dollars from charitable sources, and really put them to productive use by actually putting on these highly publicized events focused on reintegration, and really made a big splash in the veterans reintegration sector in that area. So having those kinds of case studies of this person's previous endeavors that had created a substantial impact was really helpful in persuading the government that this person's future endeavors will also be successful and impactful. on balance, it was beneficial to the United States to waive the requirement of the job offer and labor certification. How did this person prove that? So in a variety of ways, right? To first, by describing the transformative impact this person's work could have in the field of veteran welfare. Second, really to focus on the unique know-how and superior connections and understanding this person has of veterans' priorities and this person's proven ability to really make a big splash in the industry. That was proven by expert letters, in addition to other forms of evidence, and that also helped meet the third prong as well. Finally, the government explicitly recognized that this person was going to be, pretty much self-employed, right? Running a consulting firm, working with these prominent organizations, working with a variety of organizations. So the traditional way of a U.S. company sponsoring this person was not going to work. However, the countervailing benefits of this person's work would be pretty substantial. So it was really a no-brainer for the government to find for the applicant in this case that there would be a lot more to gain for the United States, for this person to be in the United States, as opposed to, forcing this person to go through the traditional labor certification process, which would pretty much disqualify him from getting a green card through this endeavor.
Perfect. Thank you, Jiyae. So we do have a couple questions, and really they're focused on the same topic, which is, does having a PhD in a humanities field either benefit or penalize the application in any way?
So there really is no limit to what kind of field that you can apply for an NIW for. Now, I am going to say practically that it is a little harder for someone in humanities to prove a broad impact, but it is certainly doable. Now, it is hard to prove with plain numbers, right? So the question is, what types of documentary evidence can you prove that you have somehow impacted the way that other experts approach this field? So what is the original contributions that you're bringing and how significant was it, right? So I don't know, if you're a linguist and if you're someone like, I don't know, like Noam Chomsky, you developed a new way of looking at how, linguistics is studied. And obviously, you are invited to conferences to talk about it. Your work is featured in media that is, specific to your industry. Your work is cited in, trade journals, things like that. Then yes, absolutely, you can support your NIW claim by saying that your work has this broad national level impact to your field as a whole. So as long as you can show a transformative impact in your field, it doesn't necessarily need to be science. That's what I'm trying to say, right? But the challenge though is how to prove it, right? Because the applicant has the burden of proof. The applicant needs to show enough evidence to, meet by a preponderance of the evidence that your work has had that global impact or will have, right, in your field. So think about the types of evidence that can support that, and if you can gather a volume of that evidence, then certainly yes, you can try with a humanities degree.
Perfect.
And
Thank
yes,
you.
we will accept cases provided that there is a viable case. Yes.
Perfect. And just following up on that, a few questions came in that were very specific to the individual circumstances, like number of publications, here's my background, here's what I've done, would I be a good fit for this? For questions like that, please do schedule a consultation. During our webinars, we don't get into your personal circumstances or qualifications. So on our website, we have a very straightforward link where you can schedule a consultation with Jiyae or any of our attorneys at a time that works best for you. So please do that, and we'd be happy to talk through your qualifications and circumstances. And also, several people asked whether they would get a recording. The answer is yes, this is being recorded. We will send you the link to that recording at the end of the webinar. All right, Jiyae, another question came in. Does USCIS check on your endeavor after you've been approved? For example, what if it goes bankrupt? Or what if you say you're going to do AI and you end up working on blockchain?
Yeah, so you should plan to continue your proposed endeavor, working on your proposed endeavor throughout your green card process. So even after you're approved for the I-140, if you apply for a green card application through either the consulate or through I-45, it is going to be a drawn out process. And if you somehow change your trajectory of your work completely, then it could pose challenges for you on whether the proposed endeavor is still valid. Now, I don't think it really depends. So definitely check with a lawyer to, review your proposed endeavor and see that it leaves room to, maybe for you to work with different entity partners, for example, or if for you to work in a variety of different areas in the same general vicinity. So the way that you frame your proposed endeavor could be very important in answering that question. Yeah, which is another reason why you should work with a lawyer to strategize on all of these points. I think we have,
Absolutely.
one last question. How early while doing a
Mhm.
PhD should we schedule a consultation? You can schedule a consultation with us anytime. We can, definitely help you sort of, think about future pathways to a green card through the NIW. Definitely note that you need to already have the PhD before you can qualify as an advanced degree professional. Now, you could have a master's and you could, technically be considered an advanced degree professional with a master's. But typically, if you don't have a lot of, previous work experience, previous, research success, things like that, it could be hard to prove that you're well positioned to advance your endeavors. So it really depends on your particular circumstances. But yeah, definitely feel free to schedule a consultation with us and, we can give you general advice.
Perfect. Jiyae, thank you so much. And to our participants, excellent questions. Do keep an eye out for our email that we'll send shortly. And we do hope to see you on future webinars. Jiyae, thank you again.
Thank you.